Hi there, I'm Doc from Barcast Audio here, and today I'm going to be talking with you about another law school tip. Today we're going to be talking about when you should start your outline, what goes into an outline, and how to improve your outlines this semester. So without further ado, let's jump in. Okay, let's start with a question I always get. When should you start your outlines? People say, oh, you should start immediately, start the first week. And that's a little bit impossible because you really don't know what an outline is when you first start law school. With that said, I do recommend that you do start your outlines earlier in the semester. And it's pretty simple. The reason is because it's a lot easier to synthesize the law when it's still fresh in your mind. The further away from it you get, the further into the semester we get. Let's say you did intentional torts in the second week of September. You're making your outline in the second week of November. You don't remember everything. You don't remember the nuances. Maybe you have it within your notes, but there's going to be gaps within your notes you can't quite fill just from memory. We'll talk a little bit about ways in which you can improve your outline, and in there we'll talk about looking at other people's outlines and sort of going from there. But just remember that you can do it. You can do it on your own. You don't need to rely on other people's outlines as long as you're doing it incrementally. Some people this doesn't work for. Some people just want to put off outlining till the end of the semester. But if you want to be proactive, if you don't want to be overwhelmed and stressing out as you get to November and you hear about finals around the corner and you start stressing, you don't know everything you feel like you're supposed to, I recommend beginning early, take your syllabus, use it as sort of a base map for your outline, set up the big topics, take your notes at the end of every week, and put them within this sort of larger syllabus-based outline and start looking at sort of the roadmap of the semester. Use that syllabus, we've talked about this before in another video, as a way to set up the roadmap for the bigger topics, the subtopics within your course, and use your notes to then supplement that larger roadmap. This may not be a perfect outline, it may not be a perfect situation or a perfect tool, but it will set you up a lot better when it gets down to crunch time and you need to have a very easily discernible, easily synthesized outline. You have this sort of master document with all your notes, and you can take that and sort of chop it down until you have the best, most pure, straightforward version. So what goes into an outline? They talk about outlines in law school. Everyone talks about how you need them to pass, you need them to do well in your class. And that's true. You need them to excel in class. It synthesizes everything you've learned for the semester. It's basically, it's hard to describe an outline as an outline, but it is an outline of everything you've learned in the shortest, most discernible form. First off, what goes into an outline is the black letter law of what you learn in the course. It's pretty straightforward, right? Everyone thinks that. So, for example, for adverse possession, you would say it requires an actual entry giving exclusive possession. The entry is open and notorious. Possession is adverse under a claim of right, and possession is continuous and uninterrupted, right? So that's the black letter law. So that shouldn't be too hard to find. You should talk about that in your class. You should have pulled that out of an actual case. And in addition to the black letter law, you'll usually have a case briefly reference, just the name. Usually we color code them, or people do color code them just to easily identify them within the outline. And that case will be illustrative of that rule in one way or another. The black letter law, typically you're not going to just have black letter law rule without a corresponding case, right? A lot of professors will say that you don't need to know the cases for the exam, which is bullshit. The reason for that is that you don't technically need to know the cases to know the rule of law, but the cases are important to illustrate the law. They're important for hypos because on the exam, the way you'll use cases is this: give a rule. You'll receive a set of facts. You'll give a rule, and in analyzing that, and you'll say, this is the rule that's being tested here, the rule, like the elements of that rule, and then you'll say, the facts of this case are analogous to those of blank, Pearson v. Post. And this is how they're analogous, this is how they differ. And that's where knowing the cases will be very helpful. And that's why we include them in our outlines, because knowing the cases is extremely important to demonstrating the nuances, that you understand the nuances of the law. So throw, number one, the black letter law in there. Number two, throw the cases in there to really highlight the nuances, the sub-rules, the elements. Certain elements have different rules within them. It sounds like a lot, but you sort of get a hang of it. And once you've done it a few times, once you've made outlines, you'll really start to feel for how this whole process works. It seems like a lot, and you don't have to have the whole case there. I see a lot of students who put their entire case brief into an outline, and that's just not what you need. You need the barest form. Why is this case included in the textbook? Why is this case something I learned? It has to be literally like 1 or 2 sentences typically. It should not be longer than that, because then you run into these 150-page outlines, and that is good for nobody. Some people have these, oh my God, my outline's 200 pages. You are an idiot. You don't need a 200-page outline. It's defeating the entire purpose. If your outline's 200 pages, you've done it wrong. You have included too much information. It's supposed to be succinct. It's supposed to be the tightest version of the rule of the cases of everything. Now, the third thing I'll mention here is sometimes your professor may include a policy rationale for the law. Sometimes you should include that. Certain professors emphasize the policy decisions more than others, so keep that in mind. If your professor is somebody who really emphasizes policy, then keep it. Know that policy reasoning, because that may be something that pops up as a sub question on your exam, and that may be an easy opportunity for points just to get a little bit more. Say, on top of all the other analysis, the policy rationale for this rule is X, Y, and Z. In light of this, then the court should rule this way. This is sort of a very abstract way of thinking about this, but it's really something to keep in mind. Finally, all the 3 things I mentioned, the 4th thing you should always include is just an overarching note, right? That anything your professor says that is really important, that they say, this is really important, this is something that you really should remember, you should write that down. They should highlight it, like write in big bold letters. Some professors say this about the Erie Doctrine and certain elements of the Erie Doctrine, and they give you hints for what's going to be on the exam. They're not always hanging a lamppost on it and oh, this is, guys, wink, 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 make sure you know this for the exam. But sometimes they do. And in that case, you should really emphasize that. Emphasize it, emphasize it, emphasize it. In remembering what your outline should include, right, you have to remember that the basis for a law school exam is applying basic legal doctrines to sophisticated legal questions. Sometimes you'll feel like the rules in your outline are maybe too straightforward, too sort of plain, but that's the point. The point of this outline is not to be overly complicated. That's why I said 200 pages is way too long. It's supposed to be basic legal doctrine, which you can apply to a myriad of sophisticated legal facts. This is your tool. This is your basis. This is what you will use, and it cannot be some sort of abstract work of art that includes every word from every case that you read the entire semester. It simply will not work if it includes too much information. So work on these. Look at other people's outlines. Look at the outlines we have on Barcast Audio and our 1L package. They're succinct. They're not going crazy with the facts, because those are not what you need for the exam.